everyone. Thank you to Jonathan for his excellent presentation, and thank you to Milton Motoka for inviting me to speak today. Thank you to the crew at the Hawaii Real Estate Commission for their great efforts at educating the public and the great resources that are available, which I will talk about in my presentation. So this is the do's and don'ts of construction contracts. And just wanted to make a few comments at the outset. This is not a self-help presentation. Contracts are very complicated documents. And so what my goal is to provide a general overview of some issues that you should be looking at as you proceed with your construction projects, and just to give you a little bit of context for what you're doing. I want to thank all of the volunteer directors who serve on their condominium association boards. I know how challenging the work is, how poor the remuneration is, and how much you sacrifice and really bear the burden of operating the association. So all of you deserve a lot of credit for the work you do to really make our communities thrive. This issue of construction contracts is a major issue these days. You know, I was looking at this article from Hawaii Business: as condos age, owners must pay to maintain them, and there's a graphic of how much it costs to replace pipes, replace windows and railings, perform spalling repair, and all of the other work that is required to keep aging buildings safe and well maintained. Why I love contracts in my professional work, and I should say that I'm an attorney with Anderson Fujisaki, and we only represent homeowner community associations of all sorts, but a lot of the work I do is with associations handling construction contracts. And what I enjoy about it is that, unlike some other problems or issues that come up with a new project, you're starting with a clean slate, and you have the opportunity to really get a good product, hopefully efficiently and economically, but also a high quality result if you prepare and do all the things that are necessary. On the other hand, if you cut corners and don't have the kinds of measures in place to protect the association, you could end up with defects or litigation, complaints by owners, and other problems. So the task is really important for your association. So what I'd like to do is just to give you an overview of the materials. And the materials are available. I presume you've downloaded them. There's 7 pages for my section with a image of a building on the front. And so I will refer to the materials in my presentation by page number, but I'm not going to go in the same order as the materials. So what I would kind of do is to look at construction preparation as kind of like the 5 stages of grief, but I just call it the 5 stages because it's really not grief. And this consists of 4 do's and 1 don't. So let me just summarize, and then I'll talk about this in more detail. So 1, do your homework. Lay a good foundation for your project. 2, do get bids and vet your contractors. 3, do call your attorney. Call your community association attorney who has experience with contract issues. 4, don't assume the contractor will do the work properly. And 5, do plan for failure. So the first step is doing your homework. And I always start with the objective. And for directors and officers of their association, your objective is to comply with your fiduciary duties. And so I've summarized that on pages 1 and 2 of the materials. Basically, the fiduciary duty consists of the duty of obedience, diligence, loyalty, and good faith. As volunteers, you may think that you owe a lesser duty because you're not paid for what you do. But in fact, you have a very high standard to follow because you are dealing with other people's money and welfare. If the project doesn't go well and you have to redo the project, you may be faced with having to assess owners and explain to owners what went wrong and why the project had to be redone, or why the costs exceeded what were projected. And there's always the potential for personal liability when you serve on boards, and that's another reason to be thankful for the sacrificial work that directors do. Sometimes I hear that directors want to follow the lead of managers of commercial buildings, hotels, large facilities. And the idea would be that if Hyatt or Marriott or some other company did something, then they should be able to do the same thing because those are professionally run operations. But in fact, directors have a higher duty than a general manager of a commercial project, for example, for the reasons that I mentioned. And there's a lot of oversight, direct oversight, because you have residents who are on site, and you have the Department of Commerce and Consumer Affairs with RICO enforcing regulated industries, and just generally the law that imposes a high duty on directors. So I think it's really important to understand what the requirements are in that respect. The other part of doing your homework is to get the project on the right foundation. And so that means making sure that all of your ducks are in order. Your condo projects are very, very complicated projects in that they're governed by documents that span pages long, many pages. You have the Condominium Property Act, Chapter 514B of the Hawaii Revised Statutes, and trying to assess a problem at your project requires a lot of preliminary work. First of all, you need to figure out whether the thing that you're repairing is part of the apartments or the limited common elements or the common elements. And you would think that it would be simple to make this determination, but it's actually pretty complicated in some cases. Obviously, the declaration should give you clear instructions for most of the things in the project, but what about the things that are behind the walls? Pipes, lines. Is the wall a common element wall or a limited common element or part of the apartment? That might help define what is in the wall, but not necessarily. There is a case called Harrison versus Casa de Amdico from 2018, where the Hawaii Supreme Court took pains to try to figure out whether different parts of this condo project in Kona were part of the apartments or limited common elements or common elements. And we could see how vexing that was for the Supreme Court of Hawaii to do. So by no means is it a simple task. It can be complicated. but you need to make that determination accurately upfront. And if it's necessary, and it is necessary in some cases, the association should do amendments to clarify some of these questions. Another question is who pays? Who pays for the work? Is this something that you're going to do at common expense? Is the association authorized to do it at common expense? These issues are discussed on page 3 of my handout. If you are involved with alterations to the project, there may be owner approval requirements that are triggered, especially if there are alterations to the physical appearance of the building. There might be spending limits. Some associations have very low spending limits, so if you exceed anything, especially for improvements to the project, you're going to have owners approve those additions or alterations. If funds are needed, you may need to borrow, and borrowing triggers owner approval by statute. You'll need 50% of the owners to borrow, in addition to whatever other requirements there are in your document. So part of the homework is to make sure that you've gotten all of these issues addressed up front, because it can take a lot of time to get these resolved. The other part of it is to hire a team. Hire a project manager if you're going to have one, a design professional to do the design work. You need to get your insurance agent involved and your managing agent. You need to be careful that if you want something, you definitely need to put it in writing and be very clear about it. Don't expect to get anything on your project without having that put into writing so that it becomes binding and part of your contract. So the deliverables at the first stage is to have plans and specifications, to have a project manual that spells out all of the details of the project, what the association is expecting. You need to deal with amendments to the documents and borrowing of funds. Second, you need to get bids from contractors and vet the contractors. Now, the DCCA has excellent resources in this regard. You can go to cca.hawaii.gov. There's a site on page 2. You can check for business registration, licensing, RICO complaints, and you'd be surprised how many boards don't do this, and they end up wasting a lot of time dealing with contractors who don't have licensing, adequate licensing. You need to really check on the reputation of the contractors and see whether they've done work that other associations have been satisfied with. And also focus on the team, not just the name of the contractor, because ultimately it's the team that does the work, and it's the boots on the ground, that make the difference. The foreman or the person in charge of the project on site can make a huge difference in the outcome. Even if you have the best contractor, the largest company with the best track record, if the people on your site are not high quality people, you may have problems. The third step is don't sign the contractor's contract. You need to look at the contract carefully. Common problems that I see with contracts that are given to associations are limitations on liability, indemnifications which are going the wrong way, where associations are not indemnified, but they have to do the indemnifying, limitations on warranties, disclaimers of liability, and the same applies for design professional contracts. Those contracts also have to be reviewed because they have the same kinds of issues in terms of limitations on liability or obligations for the association to indemnify the contractor. Typically, the contract form that is used is an AIA form, and those are excellent forms, but they do require modifications to make them apply well to your project. So have your attorney review all contracts of any consequence. And if the contract is small, I don't think attorneys would mind you contacting them and just talking about the contract, and maybe just giving a limited amount of time to give an overall assessment and pick out the really critical things. With regard to COVID, since this is a time of pandemic, I think it's important to make sure that the contractor will agree to comply with the law. You need to protect the safety and health of your residents. Make sure the contractor's employees will practice social distancing, wear masks when necessary, do health checks. From a contracting standpoint, I think the two areas are that you want to make sure that the contractor is not going to blame delays on COVID-19. So be careful about that. And you can deal with that in the contract to protect delays and also cost increases. Certainly if there are major changes that occur in the law, that there would be a need to make adjustments to the contract, either the time or the money or other things. But you need to address that up front. The fourth step is don't assume the contractor will perform. So that can be dealt with by just having procedures in place to ensure that the contract is performed properly. And I know how difficult it is to really carefully monitor contractors' work, but if you are not present there to see what the contractor is doing or have people in place, inspectors or a project manager, problems are much more likely to occur. So I would really encourage you to think about how you're going to be monitoring the work. And with regard to that, I think it's a good idea to sit down and just kind of figure out what parts of this contract are the most critical parts, what parts are the highest risk. And if you can't be there for the whole project, then make sure people are there doing those critical points, because once something is done, you may not ever discover the defect until it becomes a problem, because it may be concealed by other things that are put over it. Payment procedures are also important because problems can be dealt with before payments are made. And likewise, the punch list at the end of the project is a way to address issues before final payment. And be careful to keep a retainage of 10% at the end to ensure everything is done properly. Using consultants is really critical, I think, on large projects. It's very expensive, but it's a good step to prevent defects on your project. And fifth is plan for the future. So make sure you have adequate insurance in place. Warranties need to be reviewed. I think if there's one weak link in the contract drafting process that I see most often, it's that the warranties are not really thought through. They're just kind of pro forma documents that may not say anything or may be very inadequate. You need to read the warranties and know what you're getting. I think board members need to know if they're getting a 2-year warranty or a 5-year warranty or 1 year. The default, it seems, is 1 year, but 1 year is a very, very short time, especially for a very expensive project. Bonds, I have information in my materials on bonds and on pages 6 and 7. So know what a performance and payment bond is. Sometimes your documents will require it, but even if they don't require it, it's really a good thing to have. The final point is that, if you do your work really well, nothing happens, and that becomes maybe sort of a thankless job because people expect the job to go well. But that's really your mission is that this job will go well and that it will be like you never did anything, but all of your hard work gets paid back in having no problems. So anyway, to sum up, thank you for your attention today. The 4 do's and 1 don't: do your homework, create a good foundation for your project, do get bids and vet contractors, do call your attorney to have your contract reviewed. Don't assume your contractor will do a good job, and take steps to address that risk. And 5, do plan for your future. Thank you for your attention again, and it's been a pleasure talking to you today. Your next speaker is Joshua German. Thank you.
Hi, I'm Josh German. I'm with Insurance Associates, and